I'd like to welcome everyone to this edition of Belfint Briefing. My name is Jordan Rosen. I am a tax director at Belfint Lyons and Schumann, and I'll be moderating today's session, which I think is a very exciting session. And by the way, many of you have been with us for other Belfint briefings that we've done in person, but of course, due to conditions out there, we are pleased to present today's version of Belfint Briefing as a virtual webinar. I'd like to remind participants that the session will be recorded and it will also be posted to our website within the next several days. All participants will be muted, and if you wish to ask any questions during the session, please use the Q&A feature and not the chat feature, which actually will be turned off. So please use the Q&A feature to ask any questions during the session. I'd like to remind all those CPAs that are in attendance that this session does qualify for 1 credit of continuing professional education credit, and that there will be periodic pop-ups and polling questions on your screen, and you will need to respond to 3 of the 4 polling questions during today's session to get credit for today's session. The format for today's session will be our speaker will present for approximately 45 minutes, and then we're going to leave 15 minutes at the end for Q&A. Now, if you have any questions during the session, as I mentioned, please use the Q&A feature, and I will try to coordinate with our speaker during the session and try and get those questions in during the session, because I know it's important for you to be able to understand what is being said in order to follow the rest of the material. Also, many of you submitted questions when you registered for the session. We will be getting to those during the Q&A session. Today's session is entitled Getting Back to Work During COVID-19. And it goes without saying that all of you are here because over the past 3 months, many of your offices and facilities and stores have been closed, or if you're a facility that offers takeout service or pickup service, you've had limited number of employees in over the past 3 months. But slowly but surely, the economy is starting to reopen, and offices and shops are beginning to allow both their employees and their customers and their clients back into their office space. So there are a lot of questions regarding liability and how to allow people back in a safe manner, and what your responsibilities and liabilities are in these situations. I'm pleased to have with us today Catherine Witherspoon as our key speaker. Catherine is an attorney and a partner at the law firm of Oppett Kerman with 25 years experience in employment law as a litigator, advisor, and mediator. She provides businesses with counsel needed to manage a productive workforce and mitigate liability. She is an adjunct professor at the University of Delaware Lerner School of Business and a Delaware Supreme Court appointed hearing officer. Catherine has litigated cases nationwide, including cases in the United States Supreme Court. And before I turn it over to Catherine, I do need to mention that Belfint Lyons and Schumann does not provide legal advice. So without any further ado, I'd like to turn the session over to Catherine. Catherine, it's all yours.
Thank you, and good morning, everyone. I am really pleased to have been invited to speak today, and I think the introduction was awesome. I appreciate that very much. And so we're going to go right into the presentation. And we need the next slide. There we go. So this is titled, Getting Back to Work During COVID-19, What's the New Normal? So I have had, as an employment attorney, as you can imagine, a ridiculous amount of questions about what's going on. What are my legal liabilities? And I did review the questions that were submitted ahead of time. I do think that this presentation is going to help answer a lot of those questions. The very short answer, I will cut to the chase, is that there is a lot of legal liability out there. And I'm sure everybody sort of has a sense of that. This is no surprise. But I'm going to go through the types of legal liability and how you can minimize those for your business. And very importantly, how to minimize illness as well, for yourself, your employees, your workforce, your customers, your clients, we will get started with that right now. So our agenda is going to be ensuring employee and customer safety in the workplace and beyond, policies every business must have to reduce the liability and workplace risks, and preparing for the, as I call it, avalanche of new claims. So for now, starting with the safety issue, the best practice is going to be to follow the OSHA and CDC guidelines. OSHA is, as you're probably familiar, the Occupational Safety and Health Act, and it does regulate a safe workplace. Here's the thing. The problem is we don't have regulations. We don't have federal regulations. We don't have state regulations. So we're going to have to advise to follow the best practice guidelines in OSHA and CDC. Those are all set forth on the website. You guys are probably familiar with that already. But the answer is there is no other set of guidelines to follow. If you do follow these, the liability for injury to employees is less likely. So people are working, however, on the regulations. Number one, AFL-CIO filed a suit against the Department of Labor saying, you should have given us regulations, which made sense to me. That got tossed. The DC court said, you know, you're not in any position to ask for this. So we're going to have to wait, I guess, until someone has standing to ask for this to be done. Or there are several proposals in Congress for legislation. One of them says that OSHA must promulgate federal safety regulations to mandate companies to protect people. And one of them says all people. Another proposal is to cover only high-risk workers, which would be people who of a certain age and people who have underlying comorbidities or health issues. The Republicans have also proposed that, yes, we're on board with legislation to require regulations, but we also want we also want legislation that limits liability of companies. If they're following public health guidelines to the best of their abilities, they should have immunity, but that's only for negligence. There is no immunity for grossly negligent or intentional misconduct under the proposals. This has been going on for a while, several weeks, so we're not sure if this is going to happen. We're not sure when it's going to happen. Therefore, at the top, best practice, follow OSHA and CDC guidelines. That's just how it has to be right now. So more for ensuring employee safety. I'm sure you've heard a lot of these things. The main point here is to adopt and enforce policies preventing the spread of the illness, okay? Really, really important. As I say as an employment attorney, never adopt a policy that you don't intend to enforce. And if you enforce it in an inconsistent way, you're asking for trouble, because then people are setting you up for discrimination claims. You enforced this policy against me, but you didn't enforce the policy against that one. Not only does it create bad feelings and can be internal strife, because we all know employees talk amongst themselves, it also makes people concerned that they're being discriminated against. So we don't want that. But so that's the main theme here: adopt and enforce policies to prevent the spread of the illness. So you can do lots of things that are on the CDC website. You limit your in-person meetings, you keep it to no more than 10 in groups, maximize your telecommuting. And what's interesting, a lot of these things will no longer be mandated after a while, but in our opinion as employment lawyers at my firm, we believe that these things should be continued indefinitely until we're in a better place regarding a vaccine, just to maximize everyone's safety, to minimize absenteeism, to encourage people to come to work, to feel safe, and to make sure people are well. Let's keep people well. and of course, at the same time, minimize your liability. So encourage calling out if in doubt. The policy should say, look, don't show up if you have any symptoms. And it should have a list of symptoms, not just coughing and a fever. I've spoken to a lot of doctors. I have medical practice clients, for instance, and they are saying a lot of people are appearing without a temperature. People are not appearing with a cough. They're appearing with lots of other things going on. I'm sure we all heard about it now. The sense of smell gone, the sense of taste is gone, some nausea and diarrhea, vomiting, all kinds of other things. So if in doubt, call out. Provide your paid leave or unpaid leave with guaranteed return to the physician. There are now federal sick leave laws, which you should have heard about by now, providing for paid sick leave for people in certain circumstances related to COVID-19. Not just if they're sick, it's also if they have to quarantine because they may have been exposed. They also must be paid for time spent caring for people who have to quarantine or who are under doctor's orders or who are ill. Another reason would be because they are caring for their son or daughter who's not able to go to school because of COVID-19 or daycare, or whose daycare provider isn't available due to COVID-19. Enough said that I can go on and on and on about that, but there are paid leave laws now, and you should check the USDOL's website, and there is a poster that now must be posted as well about the paid leave. But best to have it in your policy and have everyone be well aware of this and not say, oh, I didn't see that sign in your break room or what have you. If people working remotely, email them the policies that I'm talking about right now. Require the hand cleaning, of course, the regular sanitization. Everyone cleans their workspace at the beginning of the day, at the end of the day. People don't share workplaces. You stay out of each other's offices if you can. Wear a mask or gloves. And of course, the question is, who's supposed to provide that? Well, most employers that I'm talking to are providing a couple of masks. And they're not N95 respirators. They are either the little medical masks as available, which you would get when you go into a doctor's office, that kind of mask, or the cloth washable masks. And everyone supposedly is only to wear them twice. And so a lot of employers are giving out more than one mask, maybe 2, 3 masks, so that people have a chance to wash one and wear the other. Because if you expect them to wear them daily, which is recommended and which is right now still the rule in public, to wear masks when you're around others, then you're going to need to give them some time to clean the mask. We have to think about practicalities a little bit too. And make sure you've got a deep cleaning contractor available, or that you know of someone, that you have a number handy, because that may be necessary if you have someone coming in sick. And then you realize they came in sick and they exposed a bunch of people, you may well need to do deep cleaning. And the distancing, of course, is, everyone's heard the 6-foot rule, right? But this should apply also to your conference rooms, your break rooms, kitchens. And if you can possibly do it with carols, instead of having a wide open space, there should be carols, plexiglass, barriers between people who are not able to distance by 6 feet. That's just not going to hack it in some circumstances. So monitoring symptoms, what are you allowed to do? So tests are permitted. You can require people to get tests. It does not mean that tests are required. And at this point, it's very hard to get tests, as we know. However, as things progress and tests become more available, tests are permitted. And requiring tests is permitted, and a high number of false positive antibodies tests should be highlighted in your mind. I just got one of those solicitations in the mail for an antibodies test. And I thought to myself, you know what? A lot of doctors are saying that this does no good at all. So to require employees to take those tests is probably not productive. Also, they're very expensive. So we don't want to go down that road. I think at this point, until we have better science that just because you have positive antibodies, that you're positive for antibodies does not mean that you are okay on that and that you won't get sick again. Temperature screenings, absolutely allowed. You can screen your visitors, your guests, your clients. If they want to come in, then they can be subject to temperature screening. You can certainly screen your own employees. If you're a daycare provider, you could screen your, again, your clients. And I have a daycare provider that's screening first thing in the morning before they let the child in. And then on pickup, screen again, because if they have a fever at pickup time, they're not allowed to come back the next day, which does make sense. But who's going to do these? Do you need to provide training? Do you need to have a nurse if you're a large employer? You know, whoever you already have on site, or if you have someone on call, do you need to have them come in a couple times a day? Again, temperature screenings, not the fail-safe, but if you did it, you're going to look diligent. You're not going to look negligent. You're going to have had that covered on the checklist of, I'm being careful, I shouldn't be sued. A lot of employers are doing a symptoms checklist. You can have just a basic questionnaire that says, have you had any of these symptoms? XYZ PDQ, list them. Are you coming into the office today is the first list question. Or are you interacting with clients outside the office today? Are you planning to do those things? And so if they say no, I think you're okay, right? I don't think you have to require them to go through a symptoms checklist. If they say yes to those questions, either of them, then they should be required to do a symptoms checklist. You can email these every day. You can set up something on your intranet. You can use outside services. I know Christiana Care has something like this. And there are ways to get this done. Pretty smart idea, especially if you're not limiting people by the day who are in the office. Some businesses are saying, okay, you're only allowed to come in with permission. So obviously they would do the symptoms checklist. Some businesses are saying, okay, we're going to do this in shifts. We're going to do Monday, Tuesday, Wednesday, certain people come in, and then the other group comes in Thursday, Friday. The next week they switch. So in those cases, you know they're not coming in. They don't have permission to come in. This is very important for contact tracing so that you know who was there. If someone is diagnosed, then you're going to have to go and tell people that someone was diagnosed. You may not tell them who was diagnosed. This may be very hard in a tiny workplace. I realize that, but the Americans with Disabilities Act is still in force. And we have to be super careful not to be spreading people's personal health information around. So this is the contact tracing is key though, because you need to know who they were exposing. And it goes back 48 hours is the recommendation. The last 48 hours, who were they interacting with? And then you let people know, you tell them they might want to be tested. You ask them to be super vigilant for symptoms, and that's what you do. You also deep clean the area where the person was. That's when you call your contractor. Question mark whether you have to pay for time being screened. It's possible that you do have to pay people on the clock for the time they spend being screened. Is there a class action coming down the pipe? Could be, possibly. And the law is a little bit iffy on this. We're just not certain. Different states, in fact, may hold different things. And the federal law is not settled on it. So, you know, if it's very, very short time, I'd say go ahead and pay them. If it's an hourly employee, go ahead and pay them for that. You need to train people on policies, including to whom to report symptoms or to whom to direct questions. That needs to be in your policy. Who do they talk to? How do they talk to them? So for customers, you want to limit the number of them. You can do appointment. You can say, you know, we're only allowing so many in at a time, as we're doing right now with businesses in Delaware and other states. Mandate masks. If they want to come in, they have to wear a mask. And if it's a business client and you want to invite them in, then you tell them ahead of time about the policies. We're encouraging generous return policies so that people aren't tempted to come into your store just to return things. It's you know, a good idea. Also, people can try out products at home and not linger in the store, or returns only via mail if that's something that would work for your business better, because then they're not in the store again. but free returns. As I said, erect barriers between the public and workers as well, not just your workers. I've seen a lot of plexiglass between people and cash registers discussed. Distancing, of course, everyone who's been to a grocery store knows about the floor decals. Seating in restaurants, they're staying 8 feet apart so that people have room to scoot back their chairs and still be 6 feet apart in a restaurant. Just continue to take out pickup or delivery services. And you can deliver a lot of things now that we've discovered, right? A lot of curbside things can be picked up. It's interesting that we've come up with these innovations during this time. And increase your circulation if possible. Increase the air that's coming in to the workspace. I should back up. I know someone had asked the question about, what about ensuring my people are safe in the building? I can control my own workspace. How can I control the building in which we work? We're tenants in here. And the answer is to have some policies which try to address that for your own people. So for instance, don't enter the elevator if you can't properly distance. Don't use the stairs if you can't properly distance. Wear a mask from the minute you enter the building. This kind of thing. There's going to be no liability for something that happens in the building on the way to work, in my view. The person's not even on premises, arguably. And you are not if you're not the landlord, you're not the landlord. So you're not liable for premises problems. However, if your person says, I got sick at work, how are you going to show that it was in the building versus in your work suite, right? So best to have policies addressing those as well. That would be our best recommendation.
Catherine, can I jump in for a moment?
Of course.
We have a few questions from
Please,
our participants. The first one is, the person asked, it's going back to temperature taking. Does this requirement for temperature screening violate personal civil rights? And is self-assessment at home acceptable if the employee refuses to have their temperature taken at the workplace? Let's start with those questions.
Yeah, sure. No, it is permissible to, at this point, take people's temperatures at work. Basically, the EEOC, which basically is the governor of civil rights at the workplace, has said you can do this now. If you want more information on that, go to eeoc.gov, and you'll see that is what's going on. It's sort of the suspension of the Americans with Disabilities Act, saying in ordinary circumstances, you can't perform medical tests. This is considered a medical test, but because of the pandemic, the EEOC, which is in charge of enforcing the ADA, has said that it's okay.
So if the individual refuses to have their temperature taken when they come into the office, can the employer, or should the employer accept the employee has taken their temperature at home before they came in, and take their word that on the number that they give them?
So the employer's duty is to be careful, to take the care that an ordinary person would in that situation. That's the standard for negligence. What would a person do in the ordinary circumstance to be careful, to try to protect people? If someone is falsely representing at home that they don't have any symptoms, that cannot be on the employer. However, I would say that employers should strongly encourage people to do these things, and if they need to discipline. I've spoken to a business just last week about this. A lot of people are pushing back at the business and they don't want to answer these questionnaires. I said, well, that's interesting, but if they're working and they're showing up, you can do things such as shut down their access to your system. You can, so if you don't want to actually discipline them for not doing that, well then, hey, you're not going to be able to perform your work today and we may or may not pay you. You can absolutely write them up. You can certainly have a talking to. It is your policy and you are entitled to do this right now. And it's very important not to get everybody else sick.
That's very interesting. One other question, very interesting question here. Is it recommended to purchase air purifiers for individual offices to increase circulation?
So that's not in the CDC guidelines. It doesn't mean it wouldn't do, that it wouldn't help anything, but I have no medical knowledge that that would help. I mean, it kind of makes sense. I know increasing circulation is something recommended. That's in some of the OSHA guidelines as well. But I don't know if air purifiers per se would do anything. That really kind of is an epidemiologist question, and so I don't want to veer too much into that direction. I'm sorry, I can't give you a much better answer to that.
Okay, thank you.
Sure. So we know these other things too. This list, more for customer safety, are things that are in the CDC guidelines. There's also things on the state of Delaware guidelines I should mention. But I'm still going to recommend CDC and OSHA as the ultimate sources for this. So clean hands after touching the money or touch screens, use your disposable items, use customer bringing his own bags, encourage ordering online, calling before coming in. Non-punitive cancellation policies, I think, is something that some people haven't thought of. You don't want someone coming in for their haircut because they think that, they're going to be, forbidden from ever coming back. You don't want people canceling you do want people canceling their doctor's appointments if they're sick because because they're trying to avoid paying your $25 no-show fee, etc. Psychologist appointments, whatever it is. So you want non-punitive cancellation policies in these cases. So where should you start about updating your current policies? You're going to need these policies. You're going to need to review them and consider modifications to a bunch of things. Sanitization, distancing stuff that we just talked about, some safety stuff. Your sick leave policy, which we just discussed, I briefly touched on with the paid sick leave, the federal paid sick leave. Family medical leave, there's new family medical leave laws too, which need to be thought about and need to be placed in a policy. Employee leaves of absences, that might be different now because we've got people who may need them more often, and there might be different standards now. You need a teleworking policy because people are working from home. And did you know that you can be liable for workers' comp based on an injury someone incurs at home? Yes, this is true. There is a case of someone tripping over her dog during work hours at home and successfully filing a workers' comp case. There's a case of a guy on a coffee break at home falling down the stairs, fracturing a vertebrae, and again, a successful workers' comp claim. So a teleworking policy needs to cover that too. It needs to have a checklist of things that the employee is required to go through to eliminate your basic obvious hazards. So that's something that some people don't think about as part of their teleworking policy. And you can use that going forward, of course, your teleworking policy. Paid time off, again, that might change because of the way that people are going to have problems showing up. And then other policies and procedures you should consider specifically would be limiting gatherings in the office, limiting seating in break rooms and communal areas so that everything's spread out. Like I said, employee testing or self-reporting, scheduling policies. As I mentioned, some people coming in one day or at one time, some people coming in other days or at other times. People might have to be flexible on this. You might have to work nights. Do you want your job? Okay, you want your job. This is how it's got to be for now. You say this is temporary. Your policies all say this is temporary. We will, be revising this as needed and as permitted. You need an enhanced anti-retaliation policy. What I mean by that is you cannot retaliate against someone for taking sick leave, the emergency paid sick leave or the emergency family medical leave. That's explicitly included in the new laws. So you need to ramp that up. You need to say, hey, we understand we will not retaliate against you for asking for sick time. Understand, of course, that they have to provide the documentation, okay? We're not going to say, hey, we're not going to penalize you for being absent 17 days without any documentation. But you do need to say, we won't retaliate against you for asking for it, for taking it. I skipped commuting and travel policies. So, you know, a lot of our clients, when things were really bad, said, we're going to encourage you not to commute using public transportation. That might be necessary again in the winter if this thing ramps up or sooner. We don't know exactly what's happening right now, right? So you might want to discourage commuting on public transportation. Travel policies, you may want to have a screening question that says, have you traveled in the last 14 days and to what location? Interesting, because if you ask, have you traveled to any hotspots? Then people might have a different opinion about what's a hotspot. People might not know if it's a hotspot. So the best thing to do is to require people to report if they've traveled, unless it's their regular commute, of course. And, you know, hey, have you traveled out of the county, right? And then have that done. You can also just say, if you go out of the country, you're being quarantined for 14 days. You're working at home, you're not coming to the office, whatever it is, just so the policy says that ahead of time, then you know what's going on. They know what's going on. You want to include your state-specific laws if there are other states or cities that have ordinances and laws about leaves. For instance, Maryland has paid sick leave law. New Jersey has a paid sick leave law. I do a lot of work in those states, and Pennsylvania and Virginia and DC. There are state-specific laws. If anyone's on the line that's listening from one of those states and they need to check those, that needs to be updated if not already included. Employee leave requests and tracking procedures, those, as we discussed, are very important to include in your new policies. What else should you be thinking about with policies? Consistency in selecting employees for testing. Consistency in selecting employees for any kind of documentation that's required, for leaves, for bonuses, wage and hour considerations. Like we're saying, paying people for certain times, making people track what they're doing, even if they're working at home. Establish, communicate, and adhere. Like I said, make sure you've got these policies, but make sure they're enforced and make sure they're communicated. They have to be very uniform, or else you're going to get your discrimination claims. Your leave, layoffs, bonuses have to be consistent. Make sure you maintain the confidentiality of your testing and your screening results. Those need to be kept in a separate file along with all other medical information, anything falling under the ADA, requests for accommodations, leaves, FMLA leave, any testing results, all of that needs to be kept in a separate file. It has always needed this. I'm just emphasizing that you should make sure this stuff also goes in that separate file and not in the personnel file. Very, very important. Again, there, violation lawsuits can be brought for that kind of thing. And develop a response to employees who refuse testing. So you preempted that question. We need to figure out how to do that. And then finally, it has all these asterisks in front of it because it's so important. Require sign off by the employees on policies. You don't want, I had no idea that was a policy, and so I did fill in the blank, right? Never, never, never do we want this. Require sign off on policies with the dates. Keep the sign off the understanding sheets, the acknowledgement sheets on file in the employee's file. And then you have that. You have it. It's a lot of good protection for you. So definitely put that in. So here's why you need policies, okay? And why you need consistent enforcement and to be aware of all these laws. Because we're preparing for an avalanche of new claims. There are things coming under OSHA and workers' comp, negligence leading to personal injury, Americans with Disabilities Act, we talked about that a little already, Families First Coronavirus Response Act and other sick leave. So we've got retaliation, as we discussed, and also the flat out refusal to give leave, a Family Medical Leave Act, wage and hour laws. I'm going to go into all of these in a little more detail in a couple of minutes, but we've got timekeeping, compensable time, exempt status, that might change. Unemployment comp issues. I'm sure a lot of you have already come up with those, come up against those. There's the WARN Act, which I will explain, collective bargaining agreement violations, discrimination claims, including disparate impact. You know, you passed a neutral policy, but it's affecting one group in a way that it doesn't affect other groups. And then finally, whistleblower claims. So if that's not a long list, I don't know what it is. So starting with OSHA. We have a duty to maintain a hazard-free workplace. There's a general duty clause to maintain a safe workplace. There is no private cause of action, meaning there's no right by an employee to sue you as a company under OSHA. However, people can file complaints with the Department of Labor. They show up unannounced and, you know, hey, nobody's wearing a mask. Hey, these people aren't distancing. They can walk in and look at all that. And you should never turn an OSHA inspector away. Much as you might want to, that's even worse, because then they get extremely suspicious and they really get on your case. There are record keeping requirements. If someone is sick, it is considered a work-related illness if the person did contract it at work. Okay, this is hard to show sometimes. Obviously, in these times where people, especially where people are more out and about, how do we know they didn't get it at that restaurant? How do we know they didn't get it at church, right? That kind of thing. But you have to keep records that track what's going on with people. If they're hospitalized, and it takes them a certain length of time to get over it, that's definitely a reportable problem, which must be reported because it is a work-related illness. If the person is maintaining that, then go ahead and report it. You do not want an extensive investigation by OSHA. Then we get to workers' comp and negligence. And now we are not sure what's going to happen with these. Workers' comp might cover the claim if an employee contracts the virus at work, but it might not. There are no cases, as you know. There are no cases on this yet. So we're at risk for claims of negligence, which led to personal injury or wrongful death, which would be filed by the person's family if they die. And so those are real. Those are very real hazards, and that's a reason to have the policies enforce them. Very, very important. So moving on to medical and leave issues, the Americans with Disabilities Act requires you to provide reasonable accommodation. So requests for accommodations will be going up. They will be from people with underlying medical issues, including mental health issues, meaning I have an anxiety disorder, for instance, and I can't come in because it's absolutely pushing me over the edge and it's making me very ill. So if an employee's job can't be performed remotely and they have a disability which makes them more susceptible, there may well be requests for accommodations. If you can reasonably request them, abide by the request, meet the request, then you do have to do it. But you can consider the cost. And if it's prohibitive and there's just no way you can do it, for instance, indefinite leave at home, you don't have to provide it. You should see an attorney about whether something is reasonable or not under the law. You can consider whether it's just for a limited period of time, and that makes it more reasonable. It definitely makes it more reasonable. It's also going to be hard to show that someone who's been working at home, been a productive employee at home, should not be allowed as a reasonable accommodation to remain at home. That's going to be hard to make that argument. There are boundaries of proper medical inquiries. You have to get, you're allowed to get the documentation, but there is a limit. You can't give someone the third degree. This really has not changed, except for you're going to see more accommodations requests. That's just our very strong opinion on that. There are other medical and leave issues to consider. The Families First Act, that's the one with the emergency paid sick leave. The other sick leave, if there is any state or municipal law, what's the coverage? Who's it applicable to? Is there discrimination against someone who's caring for someone, even not against the person, but because they're caregiving for someone? The state and city, like I said, there are now expansions, and you should check with a lawyer about what the expansions are to those. Delaware may well be expanding those, going forward as far as requirements for sick leave, retaliation for not providing the leave. There are suits already filed. Oh, and I should add, there are suits already filed for personal injury, not asserting workers' comp, but personal injury, and for the wrongful death. There's wrongful death against Walmart. There are personal injury claims against a lot of companies. We don't know what's going to happen yet. It's too premature, but stay tuned. We'll see. Going back to medical leave issues, so Family Medical Leave Act. You have to consider that it could be applicable to this situation. If you've got more than 50 employees, Family Medical Leave Act applies to you. And if the person is caring for their own illness or that of another, which could be COVID-19, well, then that would be applicable. 12 weeks of unpaid leave for employees who have been employed for 12 months and worked 1,250 hours during the year. You subtract for the weeks of childcare. A lot of people don't know this, but under the Families First Coronavirus Act, there's emergency family medical leave, and that's for caring for children. So if you've already given the employee during the year 8 weeks of FMLA, regular FMLA, then you're only obligated to give the person 4 more weeks. Apparently, Congress did not think this should be an unlimited situation with unpaid leave. It could get way out of bounds, honestly. If someone took 12 weeks and then another 12 weeks, we can see how that would be a super hardship on the employer, almost half a year. So comp issues, we have to be careful about wage and hour loss. We have to be careful that our classifications remain intact. If we change the duties of someone because of COVID-19, things had to be reorganized or people had to be eliminated, and therefore the one person who used to be exempt may no longer be exempt. So there's a job duties test. Again, it's kind of complicated. That's one of the things that I would say pick up the phone and call an employment lawyer about. Too many mistakes, unbelievable mistakes about this. Unfortunately, the DOL is really, really serious about minimum wage. Unfortunately for employers, DOL is really, really serious about minimum wage and overtime violations. It's a double damages and a penalty. So if they find that you did anything willfully, which they tend to find things were willful, they go back 3 years for all claims, and they'll look at every single stupid thing. They're doing the same thing with the new paid emergency sick leave. They're going to treat it as if it's failure to pay minimum wage or overtime. Same penalties. Make sure they record their time working remotely. Make sure that you think about paying for the time spent undergoing screenings if it's significant. You're probably not going to get complaints if it's not significant. But I can see a class action coming against, a Walmart and Amazon, someone like that. A bunch of people have to stand in line, and it's taking them a long time, and they're not paid for it. So unemployment comp issues are super interesting. The law is clear now that if someone refuses to come back, or they refuse to increase back to their normal hours, which were eliminated or reduced because of COVID-19, they're not entitled to unemployment unless it's a COVID-19 related reason, which could be something like, I have to stay at home now because my spouse is working full time, or I'm a single parent and I have no one to care for my children. It could be something like, I'm sick, I'm quarantining, I'm having to care for someone who's sick or quarantining. Those kinds of things they would still be eligible for unemployment, but it's a narrow place. And there's an interesting discussion going on about the Paycheck Protection Plan. And if any of you have loans under the Paycheck Protection Plan, you need to document in writing that the person was offered was offered the job back. by writing a letter and having the person sign off that they refuse to return. That has to be in writing to get credit on your forgiveness of your PPP. If you have any questions about PPP loans, I'm happy to answer those too. So here's another part of the Avalanche WARN Act. The WARN Act requires employers with 100 or more employees to provide a certain amount of advance written notice of plant closing or mass layoffs, which affect more 50 or more employees at a single site. Delaware also has what they call a mini WARN Act, which means you have to do some notice requirements for 50 people being laid off. So people have already done this, and it was excused. You are excused from the notice if it's a situation like this, in our opinion. A situation like this meaning unforeseen economic disaster. There's actually something in the WARN Act to that effect. So keep in mind, a temporary layoff of 6 months or less is not an employment loss. So you don't have to tell somebody under WARN that that's what's happening. But if the plant closing or the mass layoff extends, then you have to give the WARN obligations kick in. You have to give notice that they are not going to be coming back. It's a mass layoff. The plant's closing. And like I said, the WARN makes exceptions when layoffs occur due to unforeseeable business circumstances, natural disasters, et cetera. But you should still say, send out something that says you guys are being laid off, whether it's temporary, whether it's permanent. Always good to advise people. There are also risks of potential violations of a collective bargaining agreement if you're a unionized workplace, because the NLRB has recognized employer ability to take certain steps without union approval or bargaining when there are exigent circumstances. Also, there's a new requirement that you can't prevent people from organizing if you're taking a paycheck protection plan loan. The legislation got complicated and people put other things in it that may not have anything to do with the current pandemic. So just be very, very clear that you can't, the way we're looking at it, we're not sure you can even conduct an anti-union campaign at this point.
Hey, Catherine,
Yes.
Catherine, can I jump in? We've got a few more questions here, which I think are relevant. The first question is, if an employee refuses to come back to work due to COVID-19 issue, wouldn't they be required to do CCFRA, sick pay, or FMLA versus unemployment? Or does unemployment kick in at the end of the 12 weeks if they are still unable to return to work?
Right. You first provide the paid sick leave. That's right. Or the paid emergency family leave. And then if they cannot, because they're unable to work or telework because of those conditions, right? Then yes, then they can go on unemployment. But typically a lot of people are out of PTO, or they just don't want to return. It has nothing to do with the COVID-19 reasons.
Okay, our second question asks, are the employment liability issues also applicable for clients of an organization that reopens? An example, a senior center or members of a faith community congregation.
Right. So again, we're not sure, but we say take the level of care that a reasonable person in your situation would do. Take the reasonable care that a reasonable organization in that situation would perform. So, warnings to visitors, signage, telling people ahead of time what they need to do to comply with your policies, which you set in place, masking, distancing, et cetera. Those are gonna insulate you from liability. As far as a nursing home, again, really strict rules that are actually enforced. Question mark, who enforces them, right? Do you have to have people in there, checking on people? It's going to be hard. It's going to be hard to enforce some of this stuff. Of course, a lot of assisted care facilities have just said no visitors at all, and that eliminates that problem. It's also really hard for the people living there, though, as we know. So I just reasonable standard of reasonableness, a reasonable degree of care. That means you won't be deemed negligent if you do what seems like the right idea. If you look at those CDC guidelines, look at those OSHA guidelines, and see what can be done. When the federal regulations come out, look at those. And if you need help translating the gobbledygook, call an employment lawyer. That's what I'll be doing. I'll be sitting there for hours and hours analyzing the regulations like I've done about all this other stuff since it's happened.
Okay, great. Thank you.
Sure. Right. So the collective bargaining agreement back, there may be a duty to bargain over changes to mandatory subjects. So of course we know this, right? Scheduling, meal rest breaks, work assignments, layoffs, terms and conditions. So just think about how anything you might change might impact your collective bargaining agreement terms. That's something to consider. Think about EEOC claims for disparate impact. Decisions that you make will open the door to possible claims for discrimination due to disparate impact or racial identity. So interestingly, the EEOC is expecting an uptick in complaints from Asians. They are expecting that because people perceive of it as a Chinese virus. Very interestingly, after 9/11, there was a big uptick in discrimination claims filed by Muslims who had nothing to do with any of that and never knew this was coming and so forth, just perfectly innocent people. Same thing, they're expecting an uptick in claims by Asians. But I think really what's gonna happen are gonna be your disparate impact claims, whereby everyone gets something and you don't, right? They get a bonus and you don't, right? Only these people are laid off. You're not, that kind of thing. That's what I see. Target retaining your best people and not necessarily your most tenured employees, although, for your business sake. But if you're going to use criteria, you should use objective criteria. There should be evaluations to back up your decisions. There should be, a rationale of, we eliminated that job position, so of course we're not bringing that person back. There need to be other criteria so that it doesn't look like you're discriminating based on race, sex, disability, et cetera, et cetera. We need to be very careful. The EEOC has been super clear now that you cannot exclude people over 65 because they seem to be higher risk category according to our health advice. You cannot do that. They are allowed to assume the risk. Same with people with underlying disabilities. They are allowed to assume the risk. You can't make them stay home. So that's interesting to know. That's kind of new. And that's something you need to watch with this too. That's basically covers that. And then finally, whistleblower claims. So an adverse employment action taken by an employer in response to an employee's good faith complaint that the employer has violated the law can serve as a basis for a whistleblower retaliation claim. So whistleblower law in Delaware, among other states, protects for complaints about health and safety. So if someone is complaining about health and safety, take it seriously because they can walk out and file a whistleblower claim. This has already happened, I know, to Amazon, some other employers, whereby people were complaining about, they weren't giving us enough masks and so forth. And they were let go because, for other reasons. Sometimes it was, in the case of Amazon, it was because the person who was on the news about this was actually not following the rules. So they said, this is the reason they proffered for letting him go. And he, of course, filed a claim for whistleblower retaliation. So you have to be very, very careful about that. They may well have a retaliation claim in addition, under the National Labor Relations Act. So very, very careful about complaints. Take everyone seriously. Really look into it. And then there's a False Claims Act, which is kind of tangential here unless you're a medical provider. There may be people fudging records and saying that people died from COVID-19 when they did not actually do that. and then billing Medicare. None of you would do this, I am certain, but I'm just highlighting what is you're going to see in the news, and the people are going to file false claims acts against them for defrauding the government on Medicare payments, Medicaid payments too. So I want to just thank you for attending, and I would love to entertain any more of your questions at this point.
Well, Catherine, thank you very much. A lot of information. I learned a lot from it. I'm sure everyone on this call did as well. A lot to digest, and we do have quite a few questions, which let's start going through that now. And if we don't get to your question, Catherine's contact information is up on the screen right now, and she's been very gracious in saying that you can contact her privately with those questions. So let's start off. First question, can I be liable for COVID lawsuits while on a customer site? And follow up to that is, do I have recourse if I get COVID while on a customer site?
Yeah, that's a great question. So I think that the best practice is to talk to the client or customer prior to going on site, and ask what are the policies, and ask how they're enforcing the policies, and tell them your expectations. And, you know, in the nicest way possible. I know this is difficult. And, you know, if you as an employer send someone to another site and are not cognizant of that issue, you could run into trouble. This is definitely something to consider and to put in your policies. If you know, how is it supposed to be done if you're going to other work sites? It's questionable. It could be that you're held liable for that. Certainly under workers' comp, because during the performance of work duties in any site, like I was saying, workers' comp applies at home, then you could definitely be on the hook for workers' comp if the person can show that it's a work-related illness that was incurred during work hours at the client site or at your site.
Okay. Catherine, here's a very interesting question. How do you address situation when a customer, after being in the building, becomes infected with COVID-19 and the person claims the virus was contracted from being in your particular building?
Right. So question in the hypothetical, whether the person owns the building or whether the person is just a tenant in the building.
Well, let's look at it that the person owns the building, because I think in your presentation you sort of addressed if you don't own the building and you know, what your responsibility is as opposed to the landlord, you know, not taking all the precautions.
Right. So I think that in that case, it is your building. Let's assume that you are responsible for the building, and you have to make sure that the policies are applied throughout the building. If you have tenants, you have to be really clear about what the policies are in the common spaces. If you're occupying the whole building with your business, again, the same standard would apply, possibly to guests. I am not aware of cases yet. I'm sure they're out there where guests have alleged that they got the virus at another person's building conducting business. Again, it's going to be somewhat difficult to show that that is where they got it. Because people are out and about more now, especially, it's going to be difficult.
Sure.
So, you know, you may be able to knock it out on a motion for to dismiss, in that they can't make their prima facie case to demonstrate that. But again, I wish I could answer these questions. My best advice is to try to stick with CDC and OSHA policies, and to create your own policies and enforce them, underline enforce.
Okay, I have several questions are coming in from smaller businesses, one with under 50 employees and the other with under 30 employees. Slightly different questions. One question says, we're a company smaller than 50 employees. Does Family's First Act apply to our office? If employees need to take time off due to childcare, centers being closed, are we required to provide additional paid time off in addition to their PTO? And I think I think you addressed, what, Family Leave Emergency Act and the Emergency Act. How does it apply if they're under 50 employees?
Right. So the Families First Coronavirus Act, Response Act applies to all employers 500 or less. It doesn't apply to employers of over 500 employees. So the answer is, to the first part, the emergency paid sick leave, you're going to have to pay it out, regardless of your size. And, question mark whether that was a good idea, question mark whether that's very practical, but it is what it is. That's the law. Now, the emergency family medical leave for employers under 50, there is a case-by-case analysis, which is required if you do not think you can make it without that employee, or if a number of employees are out. Okay, so for example, someone comes to you and says, and they're your only, at this point, because you've cut back and so forth, they're your only manager of the store that can work on Monday, Wednesday, Friday. Because you've already got 2 other managers who were available to work Monday, Wednesday, Friday out. So at that point, it becomes a business difficulty that's really going to impact your cash flow, your viability. And in that case, you can refuse to provide the leave to that person. That's the leave for caring for their children, not the leave for the other purposes. So, the best thing you can do is to document that very well. You don't have to submit it anywhere, but if there's a challenge to it, you want to have it. You want to say, look, here are the records showing that I had no one to work Monday, Wednesday, Friday, and that it would have seriously impacted the viability of my business if I had let you go on leave. But it is a case-by-case analysis. The first time someone asks, remember, the hypothetical is we have 3 people. The first person asks, well, you know what? You can still make it work because you have 2 people. And so that might be a harder case to make to deny that leave.
Okay. A few more questions here. One participant is asking, is it a good idea to contract out the daily screening activities to shift risk?
Well, I mean,
can you
that's
shift the risk?
possible, but if you have someone that is proven to be negligent in doing so, then you would have a cause of action. You could say in your independent contractor agreement that they agree to indemnify the company for anything that may lead to liability from the company, and from the company being sued. And so that would be a way around the problem. Also, is it okay to say we took reasonable care if you put some person out there who may not know what they're doing? So, I mean, it can be a good solution, I think, to get a third-party contractor in there, as long as you have that safety net. Otherwise, if they do something and they're negligent and you're not paying attention, then it could still fall back on you. But if you've got that indemnification, that might work well.
Okay, we have time for one more question. This is a little lengthy. If we have a policy in place that mandates social distancing, and an employee tests positive for COVID-19 due to exposure outside of the workplace, are we required to shut down and have all exposed to this person quarantine? Or can we say that due to social distancing practices, our risk is low and exposed employees continue to work until a second person tests positive, and then it is apparent that our social distancing is not working and we must take more drastic action?
Okay, so the CDC is going to say that if one person contracts it, and they have been at work, you're going to have to notify the other people that they've been exposed, and you're going to have to deep clean the area where the person has been. If they've been all over the store, for instance, you're going to have to shut down. You're going to have to shut down per CDC guidelines and clean the whole place, deep clean. Again, maybe there'll be a regulation on this, and maybe it won't be as harsh. But we're super concerned about spread, and so all the people who have been exposed need to go out. Absolutely, your policy needs to say, if you've been informed that you've been exposed to someone who has a diagnosis, you have to go out. So it's horribly inconvenient. It's really, it's not good for the company. And it may well be that your social distancing works and no one else gets sick, but you want to be the careful employer who doesn't get in trouble for failure to follow those CDC guidelines. So that would be my answer to that one.
Okay, thank you. Again, Catherine, thank you very much for your presentation. It was very informative, very powerful in the message. And as I said, I learned a lot from it. In the interest of time, though, if anyone has any additional questions, or if we didn't get to your particular question, Catherine's contact information is up on the screen. And as I said, this entire presentation is being recorded and will be posted to our website within the next few days. One final announcement that I have to make is that if you are applying for continuing education for this session, there will be a survey that's going to be sent out to all participants. Now we ask that all of you please reply to the survey or complete the survey and send it back to us. We always read all the comments, and we want to know how we did and any ideas for future Belfint briefings, but you must complete the survey if you want continuing professional education credits. Catherine, just do you have any closing comments or words of wisdom before we sign off?
I would say just be very aware of the news. The news is covering a lot of changes to the laws because it's such a prominent thing right now. So tune in, make sure you're paying attention to the news. EEOC.gov, CDC.gov, OSHA.gov are going to be your best guidelines at this point, as well as watching the state of Delaware phase openings. Be sure to be in compliance with the phase opening guidelines as well.
Catherine, thank you very much. Before I sign off, I want to thank Jenny Jones from my office for being behind the scenes and making sure this webinar goes without a hitch. And I'd like to thank everyone on the call for participating today and listening in. Please look for the survey and also look for other emails for future Belfint briefings. That concludes our session for today. Wish everyone a good day and stay safe. Thank you.